Welcome to our voter forum for Measure 89, the Equal Rights Amendment. I am your moderator, Debbie Kaye, with the League of Women Voters of Portland. The League of Women Voters is a nonpartisan organization that works to help citizens make informed choices in elections. We do not endorse any candidate or party, but rather we give voters the particulars they need to be informed voters. Membership information is available on our website and at the table at the back of the room. We thank the Multnomah Bar Foundation, Neil Kelly Design, and Paloma Clothing for their generous contributions to our education fund, making these forums possible. Today's forum is being recorded by our media partner, Portland Community Media, and we are very grateful. All forums in the future will be available for on-demand viewing from a link on the League's website, lwvpdx.org. To view the forums on local access cable TV, see the playback schedule on the table at the back of the room and posted again on the website. Voters can also look at our nonpartisan Voter's Guide for answers to questions posed to all candidates, as well as balanced presentation of the ballot measures. The Voter's Guide is on our information table in print form and also is on our website, lwvpdx.org. You will find free copies at Multnomah County Library branches, such as this one, and at the Multnomah County Elections Office. Another important voter resource is housed at the Secretary of State's website. It is called ORSTAR and enables you to see the financial sources for campaigns, essentially to follow the money. Type ORESTAR into your browser. Finally, to see information about the candidates and ballot measure that will appear on your ballot, go to vote411.org, enter your street address, and the Voter's Guide information for only those items on your ballot will appear. Ballots will be mailed starting today, October 15th, so look for yours to arrive soon. Now to our forum. To discuss the ballot measures today, with us we have specially trained League members. Each speaker has reviewed the pros and cons of the measure and been trained for neutrality. They will present factual information about the measure, including the best reasons collected from the measure's supporters and opponents. After each speaker completes an explanation, there will be time for questions from the audience. Please write your questions legibly on the cards that are being distributed for this purpose. Our first speaker will be our co-president, Margaret Noel, who will present on ballot measure 89, the Equal Rights Amendment. Margaret?
Thank you, Debbie. Good afternoon. Measure 89, the Equal Rights Amendment. This measure's official title is Amends Constitution, State Political Subdivision shall not deny or abridge equality of rights on account of sex. This constitutional amendment was placed on the ballot by initiative petition. If it passes, it would add a section to Article 1, which is the Bill of Rights in the Oregon Constitution. The new section would say, equality of rights under the law shall not be denied or abridged by the state of Oregon or by any political subdivision of the state on account of sex. Some people have asked why the amendment says on account of sex and not gender. Although these two terms are often used interchangeably, sex is particularly used to mean the biological differences between men and women, and gender often refers to social and cultural roles of men and women. So it says equality of rights on account of sex. If this measure fails, language explicitly prohibiting sex-based discrimination would not be added to the Oregon Constitution. However, Oregon would retain another constitutional provision and laws that now protect Oregonians against discrimination on account of their sex. Oregon courts have held that men and women must be treated equally unless a specific biological difference would justify unequal treatment. More about this later. Let's look at the current situation and some history. The Equal Rights Amendment has its origins in the first Women's Rights Convention 166 years ago in Seneca Falls, New York. In 1848, women gathered and resolved to work for the rights that they were denied at that time, including the right to vote, to own property, to keep their own wages, and to have a college education. This began the women's suffrage movement. Today, women in the United States have all these rights that they demanded at that time. And they have others, including the right to work in the same jobs as men. However, there are still cases where women believe their rights are threatened, especially for job advancement, equal pay, and reproductive health care. The first federal Equal Rights Amendment, or ERA, was written by suffragist Alice Paul in 1923, just after women gained the right to vote. And it was revised by Alice Paul in 1943. And that version of the Equal Rights Amendment was, or all versions were introduced to every session of Congress before it was passed by both houses of Congress in 1972. This version said, "Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex." As an amendment to the U.S. Constitution, the ERA needed ratification by 3/4 of the states, or 38 states. Oregon ratified it in 1973. And 35 states had ratified it by 1977. However, it needed ratification by 3 more states, and that didn't happen before the deadline set by Congress, which was June 30th, 1982. So today there is still no Equal Rights Amendment in the U.S. Constitution. Meanwhile, in 1859, Oregon became a state and adopted its constitution. And the original Oregon Constitution had a Bill of Rights in Article 1, and one of the sections of the original Bill of Rights that is still there today in its original form is Section 20. Section 20 of Article 1 states, "No law shall be passed granting to any citizen or class of citizens privileges or immunities which upon the same terms shall not equally belong to all citizens." I'll say that again. "No law shall be passed granting to any citizen or class of citizens privileges or immunities which upon the same terms shall not equally belong to all citizens." That was in the original 1859 Constitution, and it's still there in the same language. Now, in 1859, women in Oregon, like the women in the rest of the United States, had very limited rights. So it's doubtful that the framers of our Constitution intended that Section 20 would grant women rights. In the few sex discrimination cases that came before the Oregon Supreme Court before the 1980s, the court decided against giving women equal rights. But beginning with a case in 1982, Oregon courts have interpreted Section 20 as providing women and men with equal rights, and have held that exceptions can only be made in cases where there are, quote, biological differences that might justify unequal treatment. It's interesting, by the way, that the case that changed the court's interpretation of Section 20 was the case of a man who asked to receive benefits that would have been given to a woman in his situation, and he won. The opinion was written by Betty Roberts. I would like to note here that when we researched the measure for our voter's guide, it was suggested that we include an example of unequal treatment justified by biological differences. And we agreed to add the words, quote, such as providing pregnancy leave to working mothers. That example has now been deleted from our online version of our voter's guide, but it still was in the printed voter's guide. This is because in 2007, the Oregon legislature passed an anti-discrimination law for employment that says, women affected by pregnancy, childbirth, or related medical conditions or occurrences shall be treated the same for all employment-related purposes, including receipt of benefits, as other persons not so affected, but similar in their ability or inability to work by reason of physical condition. So everybody, men or women, whose ability to work is restricted by a physical condition would be entitled to the same amount of leave as a pregnant woman. Clearly, Oregon lawmakers and Oregon courts are treating men and women more equally now than ever before. Oregon courts now apply the highest standard of strict scrutiny to any case involving sex discrimination. Strict scrutiny means that a court considers a policy or law invalid unless the government can demonstrate that it has a compelling interest to justify it. Oregon courts have continued the protections against sex discrimination through case law, that is, law established by previous cases. However, there is no specific provision in the Oregon Constitution declaring that men and women should be treated equally, and that's what this measure would provide. Measure 89 would add an Equal Rights Amendment to the Oregon Constitution, and this amendment has 3 parts. It says the Constitution of the State of Oregon is amended by creating a new Section 46 to be added to and made part of Article 1, section to read, 1, equality of rights under the law shall not be denied or abridged by the state of Oregon or by any political subdivision in this state on account of sex. 2, the Legislative Assembly shall have the power to enforce by appropriate legislation the provisions of this section. And 3, nothing in this section shall diminish a right otherwise available to persons under Section 20 of this article or any other provision of this Constitution. The first 2 parts essentially echo the federal Equal Rights Amendment that Congress passed in 1972 with appropriate adjustments for a state. And the 3rd part of the Oregon ERA was included to ensure that our Constitution will continue to protect other disadvantaged groups against discrimination, even if they are not explicitly identified. So what are supporters and opponents saying about this? I should note here that there is no organized opposition to this measure, in that no organization is campaigning against it, and there are no opposition statements in the voters' pamphlet. But certainly there are groups and individuals who think that passing Measure 89 is a bad idea. So we'll be talking about their reasons for that. However, none of these opponents to Measure 89 is opposed to equal rights for women. In fact, many of the opponents to an Oregon Equal Rights Amendment support a federal Equal Rights Amendment because the federal courts do not review cases of sex discrimination with the same high level of scrutiny as Oregon's courts do. I'm going to read what the supporters and opponents say in the words that each side approved and that are in our voters' guide. Supporters say, 1, an Equal Rights Amendment must be added to the Oregon Constitution to protect women against sex discrimination. As the Attorney General's certified ballot title summary states, no current provision in the Constitution expressly prohibits discrimination based on a person's sex. 2, 4 former Supreme Court justices, Oregon Supreme Court justices, felt compelled to respond to opposition statements with an open letter saying that the opponents are mistaken. Oregon's protections against sex discrimination are not as strong as they could be because they are the result of case law and because of the exception for biological differences. The 4 former Supreme Court justices, the ballot title and legislative council also affirm that the Equal Rights Amendment will not diminish the rights that are currently in the Oregon Constitution for other groups. All citizens would continue to have the same legal rights to protection against discrimination that they have now. And finally, the 4 former Supreme Court justices said, quote, "We believe that passage of the Oregon ERA will acknowledge the contributions and importance of more than 50% of our citizens by finally providing women express recognition in our state's most important document, its Constitution." The opponents say this: this amendment is not necessary. The rights of all women and men are already protected by Article 1, Section 20 of the Oregon Constitution, along with the Oregon Supreme Court's application of the highest standard of strict scrutiny to cases involving unequal treatment on account of sex. 2, amendments to the Oregon Bill of Rights should be made only if they would add protections that are not already guaranteed. Constitutional changes should either advance rights that are not already protected or end an injustice permitted under current law. This ERA does neither. 3, protecting rights in a piecemeal fashion, especially for purely symbolic effect, may mean that groups with less money and political clout will be left out. The fundamental liberties guaranteed by the Oregon Bill of Rights will be most secure if the rights of all individuals and classes of persons receive the same strong protections. And finally, passage of the Equal Rights Amendment may not automatically guarantee equal rights for men and women any more than the Constitution does now. The Oregon Supreme Court would ultimately have to determine the ERA's meaning. And I would like to add to that that even the supporters of the Measure 89 appear to agree that passage of the Equal Rights Amendment may not automatically guarantee equal rights for men and women. In explaining why we should pass the measure now, some supporters, and these were people at the City Club of Portland, have said that this is the best possible time to adopt the ERA since the current Oregon Supreme Court justices strongly support the interpretation of Section 20 that gives equal rights to men and women, and that would ensure that the Supreme Court would interpret the ERA to protect women's and men's rights and therefore work against eroding those rights in the future. So they're using this argument in 2 different ways. And I will point out that in the 1970s, the federal ERA was opposed because there were concerns that the ERA would harm families and would increase abortions or cause women to be drafted. And none of the opponents of this measure bring up those concerns.
Thank you, Margaret. Thank you for your thorough explanation. We have a few questions for you and would also like to invite the audience to submit questions. Please fill out a card if you have one. The first ready question is, how many other states have constitutional protections like these, and are they helpful in those states at preserving or encouraging equality?
Well, there are 22 other states. There are 22 states that have state equal rights amendments. And one of the interesting things is that some of the states who have state equal rights amendments are ones that did not ratify the federal ERA, and that would include Illinois, Virginia, Utah, Florida, and Louisiana. They all have state equal rights amendments. I have read that it isn't clear whether, and I think it depends on the case, whether having the ERA has made in cases where there was a question about women's rights but maybe pitted against other rights, whether that has really made a difference or not. In some states, apparently it has, and in some states it hasn't.
Right. Are inequality cases brought in Oregon very often? Is there a way to know that? Do we have reason to believe that this amendment will be used frequently? Or is its power primarily in discouraging inequality in the first place?
I think from the point of view of the supporters, its power is mostly in discouraging any kind of inequality in the first place. They are more concerned about the future than the current situation. I do know that there have been cases in Oregon of where girls' rights or women's rights, for example, to play on sports teams that are generally men's sports, have been taken up in court, and this is our current law, our current interpretation of Section 20, providing equal rights, has helped in those cases. I am not an attorney, so I don't know whether the current interest in sexual harassment and so on is also something that it shows how tuned into women's rights we are nowadays. But I believe the proponents, the supporters of this measure, are more concerned about what might happen in the future and a little bit of whittling away of our rights with a future Supreme Court or a future legislature.
Thank you. Are there questions from the audience?
Do you have a card?
There's one coming. Thank you. The question is, doesn't this establish state policy? At the highest level, the Constitution is not case law. Isn't it time? Current is important to supporters. So does this establish state policy?
Well, obviously, it gives it a little more power to put it in the Constitution. That's why they want to do it. And the person who asked that question is one of the chief petitioners, Leanne. Yeah. Yeah.
All righty. Thank you. Any additional questions? Another one. The question is a procedural request asking you, Margaret, if you could please restate that supporters are not arguing both sides, that case law is not the same as the Constitution.
No, case law is not the same as the Constitution. Case law is based on the court's interpretations of a case, and it establishes by the Supreme Court's interpretation establishes how law will be applied in the future. So it's built on cases that have been decided by the Supreme Court in the past. And putting it in the Constitution is a lot stronger.
Thank you. Absent any further questions, this concludes our presentation of Measure 89, the Equal Rights Amendment. Thank you so very much.
Thank you.
Our next presentation will be by League member Norman Turrill, and this will be on Measure 87, allowing state judges to be employed at public universities and in the National Guard. Thank you, Norman.
Good afternoon, everyone. If you're following along with me in the voter's guide, this is on page 5 of the state voter's guide. So Measure 87 is a constitutional amendment that was placed on the ballot by the state legislature by a vote of 51-7 in the House and 29-0 in the Senate. The title is Permits Employment by State Judges by National Guard, which is military service, and state public universities, which is for teaching. If the voters pass this, it will allow state court judges to be paid to teach at public universities and to work in the Oregon National Guard, both of which are state institutions. If the voters reject this, then neither of those things will be allowed. So this is a bit of a housekeeping measure that the legislature decided it needed to move on. Our state constitution is quite long and complicated, and there's a lot of little arcane features of it. But one of the actually more important features of it is a separation of powers clause that requires or limits any one branch from exercising the core functions of another branch of the government. And this is to prevent the concentration of power and to provide for some checks and balances in the state government. However, this measure arises or indicates that there might be some conflicts of interest for these state judges, and we'll get into that. Currently, there are 3 law schools in the state: Willamette University, Lewis and Clark College, and the University of Oregon Law School. Currently, there are, in fact, a handful of judges that are serving in the private universities, Willamette and Lewis and Clark, but because of this separation of powers clause, they're not permitted to teach at the University of Oregon Law School. Similarly, when this was being discussed in the legislature, somebody pointed out that judges also couldn't serve in the National Guard, which is a state institution, and so they added that to the proposal. There is no financial impact for this. There's no state funds that would be expended if it was passed. It simply makes these 2 small changes in the state constitution. So the supporters of this say that Measure 87 will allow judges to contribute their wisdom and experience to the preparation of the next generation of lawyers and judges that are attending the University of Oregon. And they could then be also paid if they worked at the University of Oregon. Supporters say that it allows judges to serve in the National Guard for pay without concern of a national challenge. This doesn't really say whether there is currently any judges serving in the National Guard, but I think there might have actually been without any particular challenge to that. The opponents of this measure say that judges should focus on their courtroom jobs and not be distracted by a teaching job. The opponents also would say that judges should not risk being called away from their courtrooms for National Guard duty. So not only could they be called away during some emergency within the state, the National Guard has occasionally been sent to Afghanistan or elsewhere in the world. So this is pretty straightforward. Are there any questions?
We have a couple questions already ready, and thank you for your explanation. Do we have a sense, I think you've addressed this, but of how many judges this change will affect?
We actually don't know. The League has tried to discover this. We're aware that there are a handful of judges that are serving in the private universities at Willamette and Lewis and Clark, but it's a very small number. So let's say 6. And so a similar number might also end up teaching at the University of Oregon.
Does lifting this prohibition open justices up to any conflict of interest by being employed by multiple branches of government?
Actually, it might pose some conflict of interest, but it's easily taken care of, because if a judge now finds himself in a conflict of interest for whatever reason, he can just recuse himself, and then another judge is assigned to the case. So it's no big deal, even if there is a conflict of interest.
Okay. A question from our audience. Isn't it correct that judges can teach at the University of Oregon and serve in the National Guard, but cannot receive pay? Can they not volunteer, but not be paid?
That is my understanding.
Any further questions? There's one being written. Thank you. Does this open up judges to discussion of possible cases? I mean, if in a teaching situation, would a judge be asked questions about a current case that should not be discussed?
Yeah, I think there's already judicial rules of conduct that would limit their talking about current cases. They always talk about past cases, but current cases or future cases they would already be prohibited from discussing.
Any more?
Okay, you're...
Short and sweet. Thank you very much, Norman.
Thank you for being so easy on me.
This concludes this section of today's forum. We thank each of our speakers for participating, and thanks also to our volunteers. Please check our website, LWV-PDX, to view our forums on demand and for replay dates, times, and channels for local access cable TV. Pick up the Voter's Guide here and at your local public library. Online, check vote411.org for a preview of your personal ballot. And Vote 411 is not only a preview, but there are also links to information about the ballot measures and the information that candidates have provided, as well as their answers to our questions. Election Day is November 4th. As in all Oregon elections, voters will receive a mail-in ballot. We do not have polling places any longer in Oregon. Ballots must be mailed back early. It is recommended that you get it into the post box by Halloween, or delivered by hand to an official drop-off site anywhere in Oregon no later than 8 p.m. Tuesday, November 4th. Postmarks do not count. I repeat, postmarks do not count. I'm Debbie Kaye with the League of Women Voters of Portland. Thank you very much for your attention. Please be an informed voter and remember your vote counts. Thank you. We're going to recess for about 10 minutes. We're going to start our next session a little earlier than is on the schedule because both of our speakers are here. So stand up, stretch, then get comfy again.